When we move into my room, she's not here yet, and then somebody could guys back there.
That's easy.
You're talking the clerk's room, or are we going to that room?
But you know, they
Okay.
have to call us, so we.
Well-
come on.
Kathy or Kathleen and others.
Yeah.
All right, so why don't we get this meeting started? Calling this special meeting for Loch Alpine Sanitary Authority to order at 3:04 p.m. Clerk Flintoff, please call the roll.
Dorney,
Here.
Brabant, absent, Angelo, D'Angelo,
Here.
excuse me, Harms,
Here.
Flintoff, here, Carrie,
Present.
Yeaple,
Present.
we have quorum.
Clerk Flintoff, could you, well, okay, adoption of, I guess the adoption of the agenda. For this, we have a special meeting notice, and clerk, if you could read the motion, please, for the closed session. That's the purpose why this meeting was called. And
Sure, we've called a special meeting for the purpose of discussing the sewer backup that occurred in May 2025 and information relevant to the pending claim. I anticipate making a motion to go into closed session, but I wonder, Jillian, if we might want to have any public comment before then
Oh.
or after that.
we can do that before. I thought I heard a door. I'm just hoping she would show. This is the time for members of the public to speak to the board, not the Board of Trustees, but the board, the LASA board, for up to 5 minutes on any matter. Anyone present would like to speak?
Sure.
Mhm.
Hello, Kathleen Brandt, Scioto Township trustee. I'm just gonna do this off the cuff. I attended your last meeting last Thursday, and I will tell you, I found it very contentious. And I've had 2 conversations with 2 members of this board, neither of which acknowledged what I was saying. That's their choice. But I will say, and this is on the video, and it's highly objectionable, and I'm here to defend Scioto Township's clerk. Mr. D'Angelo, when the clerk was introducing the item for discussing the articles of incorporation, he interrupted her. She acknowledged. She let him go. I discussed this with him just now. His words were, I've had this independently verified by 2 other people. I did not prompt them with what I heard. They heard what I heard. They even slowed the volume down so they could hear it. Mr. D'Angelo said to our clerk, I'm going to totally trash you for about 5 seconds. That is not acceptable behavior for this board, an elected official against the Scioto Township clerk. Very objectionable. I'll be sitting here, I'll be listening. You really shouldn't do that. Thank you.
Thank you.
Thank you, Kathleen.
Anyone else present? Anyone online, please?
Please raise your Zoom hand. First up is Rob Pattinson. Hi, Rob.
Hello, everyone. Rob Pattinson, Scioto Township resident. Last week, I asked this board, it's been May 6th to now August 25th. That's way more than 90 days. The attorneys and the insurance representative at the time said that the Lucan family would have to wait for 30 to 90 days. It's now been way over 90 days. Has there been any response to the Lucan family? And considering you're going into closed session, will this board be providing any explanation for any results of that closed session to the Lucan family, to the community? Is there any resolution anticipated in this meeting that that you can share with the community? Thank you.
Thank you, Rob.
Thank you.
I see no other hands. Jillian?
Okay,
Is that just Rob's hand still? Oh, yep.
we're, I don't know what you see.
Oh, there was a hand up and it went away.
Oh, okay. All right. So we are,
I'd like to make a motion. I understand from our attorney, Matt Jane and Tom Landa, who are here, that we have an attorney-client privileged memo. Given that, I'd like to make a motion to enter closed session to consider material exempt from discussion or disclosure by state or federal statute as permitted under MCL 15.268 subsection H.
Support.
um, let's do a roll call vote, please.
This roll call vote requires 2/3 of members serving. Dorney,
Yes.
D'Angelo,
Yes.
Harms,
Aye.
Flintoff, yes. Carrie,
Aye.
Yeaple.
Aye.
Motion passes 6-0. We are now entering closed session at 3:10 PM. During the duration of closed session, this board will move to the front conference room and we'll put this room on mute and pause. We'll be back when we return to open session.
I was gonna speak over.
You were not on the board of last time? Okay. So is there a motion to come out or to close? Is it to close session?
Go into, return to open session.
Return to open session
So-
at 4:48.
I'll move. Second.
All in favor, say aye.
Aye.
Motion passes 7-0. Okay. So we have two other items, but we need to amend the agenda to include these items because this is a special meeting, which Clerk Flintoff did. Thank you for publishing that portion saying that there may be additions. The one that we talked about it last week on August 21st is the Monroe Plumbing and Heating. This is for the air handler replacement. That's one item. And I did bring the proposed, well, this is the adopted capital improvement summary, and also Colleen from Woodhill had sent over the financial analysis. So you have those. And then Clerk Flintoff, what was the other questions?
Sure, I
Go
would
ahead.
just make a motion if we could add the proposal for the air handler and then also questions for our attorney related to the provisions in the proposed restated and amended articles of incorporation. We'd flag that we wanted to talk a bit today if there's time.
Okay, is there support for that motion?
I'll support it.
Okay. All in favor, say aye. Aye. Is there opposed? Anyone opposed? Motion passes 7-0. I can't hear Andrea down there, so I'm assuming that you're saying, okay.
It's 100 miles from the point.
All right, so,
Sorry.
the adoption is amended with the air handler.
Is that going under unfinished or new business?
Well, I guess.
I would
yeah,
just
unfinished.
suggest take them in this order, yeah.
Yeah,
In unfinished?
yes, both under unfinished, and then questions and answers for articles. Article revision, if you have any. Okay, so the air handler, as Brandon from F&B had explained, that it was an item or a piece of equipment that had broken down a couple times. They fixed it as much as possible, and it's just needs to be replaced. There was also insulation that needed to be replaced, so that's why there's a I think 1,300 that is included. And we had a question, should have been under the capital improvement plan, but at the time Brandon did not have the quote. He was had requested quotes, but they hadn't come in time. So that's why it wasn't included. There was a little bit of a miscommunication there. So you have the capital improvement summary for 2024 through 2035, and then also the financial analysis. According to Colleen Coogan from Woodhill, she said that this would have to be, what did she say? From the available reserves. And Ryan, you had asked, this is what you asked earlier, right? That she
It's
said.
not ideal, but it's
Okay.
what she provided.
May I bring up that this is a safety issue for the staff working in the headworks building? You know, the whole point of the air handling driller is to remove dangerous gases from the headworks building to keep them safe so they can work in there. And this is a very vital piece of equipment. You make sure it works.
Thank you.
Otherwise, you're just stuck with a staff who has to go in with scuba gear to repair stuff.
Oh,
And I don't, this is a lot easier than we're always working in scuba gear.
Yeah.
And it'll also help your equipment last longer, because it's not only removing those dangerous gases from the people, it's also removing it from the equipment.
that makes sense.
And it'll make the equipment in that room last longer.
Okay, thank you for that additional information.
I mean, I support this. I think it's obvious from the red. You know, we need to have a longer conversation about our capital plan at a future date
Oh, yes, I
and
did.
reserves.
I did verify with Brandon that there's no other items or equipment or anything that was not included in the capital improvement plan that should have been. So this was the only thing. So is there, let me see.
Down here, we have, okay, the 21/7,
Mhm.
and then these other things add. Does Andrea have any recommendations on like removal and installation of exterior air supply?
We're in a good space. You're lucky this is an exterior air supply and it's not in the building, because then it would have to be explosion proof, and this would be it'd be a lot more expensive. You'd be spending $100,000 for it.
So you're recommending then that we take the 21/7 plus 2000?
Yes.
Yes.
Yeah, well,
Okay,
based
Yeah.
on what,
Well, I don't know if you want the 1 year, if you want to add the labor and warranty, that's up to you.
okay.
But this is a vital piece of equipment, and it will save, it will keep
Oh,
people
no.
safe, and it will also prolong the life of everything in the headworks building.
well, wait a minute, that 1 year labor warranty is included.
Eh.
So number two,
Okay.
everything's included,
Okay.
excluded is just the.
other one.
So this is,
This says,
she's
sorry,
recommending
I got the impression from 2.2.3 1 year labor warranty, add $2,000, that
Yeah.
was separate.
Okay.
Yeah,
And-
this is written, this is specifically for the first and necessary material, labor, tools, equipment for the removal, installation of mechanical systems. We quote the sum total of 21,700. If you want a 1 year labor warranty, it's add $2,000.
No, it's not. It says number one, working hours. The above quote is based upon the following working hours, and then number two is included 2.1, 2.2, and 2.3.
Okay.
I disagree, but fine. I'm not.
Yeah.
Well,
It's
that's what,
not clear because it has.
Yeah.
Yeah, they did not write it very good.
So the,
but that's what Brandon had told me, is that the portion, number two that says included was included and number three is excluded. But he was recommending the insulation because there's something that when they went in there, it was deteriorated already, so. But
so I'd like to see it, but I'd like to see Brandon talk to them about that warranty. That seems excessive. 10% for 1 year warranty on stuff that they should warranty anyways, their work.
It's a labor warranty.
Yeah,
Oh, they're okay. You're saying not only the equipment, but the labor should. be-
yes, I mean, that seems a lot.
Hmm.
Yeah,
I don't know.
that is pretty stiff for a labor warranty.
Yeah, for a 1 year labor warranty, that's stiff.
And just a timing question, is this something that it'd be, sounds like this is something that would be good for the operating committee to kind of workshop a little bit. Is this something that can wait till September 11th, or does it need action
No.
tonight?
No,
It takes. a
Needs
month.
action tonight? Okay, that's
Yeah.
fine.
I mean, part of that, he's saying, so you got a lead time of 6 to 8 weeks.
Right.
Part of the thing that he said for this too, the air handler is responsible for heat
Mhm.
in the building. So we're getting, I mean, if it's gonna take a month and a half to 2 months, and that's not even the install,
Mhm.
yeah, we're gonna be into December if we wait, so.
So Jillian, did you have a motion or?
Yeah, a motion to approve.
The 23,000?
Yeah, it's, yeah, yeah, 23,000 for the air handler, unit. Air handler replacement, including the removal and installation of exterior supply insulation from our reserve fund, which there's no, I don't know what, there's no numbers, no line items here, or, budget.
That's
I don't
fine.
know if that's-
Capital reserve.
Would that be,
Yeah, that's sufficient. We just have 590 and 591. You can just say capital reserve.
okay, from the capital reserve?
Second,
I'm okay with that. Did you want to look at the $2,000, like if we did up to? Or do you want to just go with, okay, it's $2,000, we think it's kind of high, but we're gonna do it? Is that for that part, or?
I'd like to see him talk to him about that. I mean, and get that down. Yeah, we can do up to,
223, that way you could do it either way, and then.
okay.
but I have concerns about that. It seems excessive.
I'd like them to clarify if the add 2,000 is, part. Is that optional?
So Mike
But-
says to modify the motion to say up to 23,000
Right.
versus for 23,000, and then we could.
Pending F and V revisiting that.
Do you want me to
Labor
call
warranty.
Brandon right now?
That's a good idea.
I don't know that he's gonna have an answer to it right now.
Well, it
I'm-
doesn't.
I mean, if we approve it up to that amount,
We're good.
he
Okay,
can
let's-
give us a report on it next time. and
Okay,
Hopefully he can get him to go down on that. There's not a lot of people that do this.
right.
So unfortunately, sometimes you're stuck with it, but it doesn't hurt to ask.
Oh, sure. Yeah, and that was part of the issue why he didn't have the
Yes.
votes at the time of the budget capital.
We
improvement.
would like him to revisit that number and try to get him to bring it down.
Okay,
But you need to amend your motion for that.
And is there support from Tony to approve up to 25?
Yes.
23, right?
23.
Up to 23, because we're at 21,700, including $2,000. And then excluded would be the 1,300, which would bring it up to 23,000.
Yes.
So the not to exceed number is
23,000.
23,000.
Yes.
Clerk Flintoff, could you read the motion?
Motion to approve up to $23,000 for air handler replacement, including removal and installation of exterior supply air insulation from the capital reserve funds.
Okay. Is that acceptable?
Yeah, but do you want to also put in there with the understanding that they will revisit that number,
So,
the warranty number?
That the F and V or Brandon?
Yeah,
from
that Brandon
F&V.
revisit that warranty number and see if they can bring it down.
Okay,
But you have to amend that, Jillian.
Yeah.
That was your motion.
yes. There's a.
Yes,
Okay.
so with the modification that we would say from the capital reserve funds with the understanding that F and B will revisit the warranty terms and cost.
Sounds good.
And you support that?
Yes,
Okay.
yes, I do.
Okay, all in favor, say aye.
Aye.
Oppose? None, motion passes 7-0. Okay, thank you for that. I will get right on that with Brandon. Okay. Thank you for staying, Matt.
Yeah.
So if we have. Yeah, please. I just.
So this is revisiting J1 and J2 from our last meeting, which were the attorney drafted, proposed, restated and amended articles of incorporation. And J2 is sort of the proposed process regarding the appointments. So Matt, I know there was some particular questions and I'll turn it over to Mike. I think particular questions related to the Loch Alpine Improvement Authority seat. Mike?
Okay, so my first thing was, I will formally apologize for the interrupting way that I brought this up the last time. Cause I was just very late. So what I saw was, a couple of things, about the appointment of the Loch Alpine representative. And, I had seen some things indicating that we could not do that because it was somehow unlawful or illegal. And then, that was not what I personally found when I looked into it, and not what I had heard from other people. Including the original, I guess it was 2015, that actually says it's. I mean, there's a different, I don't disagree at all about maybe this is not the greatest idea. Or it doesn't look right or whatever, but I never saw anything that said we could not.
You want me to address that,
Yeah, go ahead, so.
or you wanna, I mean,
No, so but underlying all, I'll just go ahead for a little bit. So underlying all of it is, to the extent that we want to not do that anymore. If there was a way to put in the articles of incorporation, something where they would give us their nominee and we would approve them absent something like criminal history or something that's, why we don't want them. Well, rather than, just to make it so that it's still really their decision, I would literally be fine with that, like, personally, right? I know we might have, and I think Jessica had this idea that we would deal with that a little separately, but I'd like personally to see that thing in the articles, just because, then it kind of, it's weird, it's not us, I'm never worried about what we're gonna do. It's always like the people after us kind of, and, so that's what I brought up that.
so, on the first question, there's nothing that I've seen in the statute that, under which loss is created. That's Act 233 of 1955, where two constituent municipalities can incorporate an authority for the purpose of acquiring, owning, improving, operating a sewage disposal system and water supply system. That nothing that would prevent the LAIA from, or nothing illegal or unlawful about LAIA appointing the seventh member of the LASA board. The statute is silent on how the officers and governing body is selected. It just, the articles have to state, the powers, duties, and limitation of the authority and its officers, the method of selecting its governing body, officers, and employees, okay? So you just have to set forth in the articles the method by which you're appointing and selecting your governing body and officers, okay? So the original articles in 1957, I think it was, had the board comprise of each trustee from both Webster and Scioto. All right. Then the First Amendment in 1971, and this was carried over in the Second and Third Amendments subsequently in 1975. I forget what the Third Amendment was.
98,
passed.
98.
98. The Article 7 of the Articles of Incorporation was amended to provide for the LAIA Board of Directors to appoint the seventh member. So that's been how that issue's been handled for over 50 years. Okay, so I don't see anything that would prevent you from continuing with that. That's a separate question of, do you think that's sound policy? Okay, to give discretion to what's essentially a private group, unfettered discretion to appoint a member to the LASA Board of Trustees. It's my understanding that when the issue of revising and amending the articles first came up, with Mr. Fink as the attorney for the association, that it was discussed and looked at and recommended that that seventh board member the process to appoint that seventh board member be changed from allowing LAIA to pick it to the LASA board selects someone from the LASA service area. One of the reasons I believe is because LAIA comprises 80% of the service area, not 100%. So you'd essentially be shutting out, potentially 20% of the customers. That's how it was. The proposed revisions were drafted and discussed with the committee. And when I took over for Jim, I, understood that was a potential question or issue and highlighted that in a red line to show, okay, this is being changed, right? We're moving away from having LAIA appoint that seventh member to it being a LASA board appoints a seventh member from the LASA service area. And, of course, we're still in the process of discussing and reviewing, and although SIO's voted on it, they've, my understanding is they've said if any changes are made, then they're going to go back and look at it, and it still has to be approved by Webster and by this board. So it's not too late to change that method by which you would select the seventh board member. I think it's not, like I said, it's not unlawful to keep it that way. The question is really, what do you think the best approach and the soundest policy is? And in terms of adding more language to the articles about how that process occurs, you can do that, and maybe it would be better to add some additional language to suggest, okay, if the seventh person is appointed by LAIA, they have to meet certain qualifications, and it's subject to the reasonable review and approval of the LASA board. Such review or approval should not be unreasonably withheld or something like that, right? There are different. We can work with some language or propose some language to add, if you want to keep LAIA having the ability to appoint a board member while still giving you some power to say no if something really objectionable comes up, or the person is found to be, this is their first board, for example, or whatever it is.
So with that, the other thing was, so Jeff had brought up, maybe having, because we do understand the 20%, 20% art in Loch Alpine. Another person like we're trying to figure out if we need 8 or 9, or if
probably suggest an odd number, just so.
I mean, that's what, yeah, so, cause we have two other subs and.
Yeah, I
And you
mean,
know, it used to be that the president and the clerk of each of SIO and Webster were automatically appointed here. And it was thought that to have some more discretion or, you know, variety, whatever it was, that it just be changed, that each township has the ability to determine who they want to appoint to this board. And you can, you know, we can add language that sets some standards for that, or we can just say each township board shall have the, you know, shall implement, you know, policies or rules, or to determine, you know, who they will appoint to the LASA board.
but there was, so with that section and that specifically, is there any particular reason other than it may be more convenient for the boards to decide? Is there any reason to change it? There's not a legal reason that I can tell with that as far as the clerk and
There's
the
no legal
supervisor
reason-
or-
There's no legal reason to do it other than to, you know, update it and perhaps, you know, add some greater flexibility to each township having the ability to put different people on the board rather than it just being automatic, you know, certain officers automatically get on.
right?
And I can tell you at least the policy background at the time when Jim Fink recommended that was, you know, and it goes to your point, Mike, too, was, you know, it's rare that township boards have LASA members on them, but LASA residents on the boards, but sometimes it happens. Each board often finds that valuable. So I know we had Patrick McLaughlin, who was a trustee for a while, also a LASA resident. So the thinking, when Jim drafted that, was that to give more flexibility so that the boards could, if you have somebody who's a water and sewer expert, if you have somebody who's an engineer, if you have somebody who's a LASA resident, the boards might be able to appoint some people who have more relevant knowledge and connection to the LASA operation than most do. Now, this was in like 22, 23 when this was drafted, and it was all prompted when our, you know, then supervisor had stepped down from LASA. The LAIA, Jim recommended those changes for two reasons. One, make it LASA customer instead of appointment by LAIA in order to enfranchise the entire LASA customer base, the full 100% instead of the 80%. I mean, I guess it's feasible that LAIA might appoint somebody outside of their homeowners association, but that was the change for LASA customer. And then when Andrea and Mike and Matt and I met, you know, I think there's also just a discussion about, you know, how much detail to put in the articles around process, which I agree with Matt is fine, or it can be outside of it, you know, in a resolution, whatever process it is. And whether it's, yeah, bylaws, what resolution, whatever the policy is, typically articles are pretty lean, but they don't have to be. I would also say another idea Jim Fink had, but Dave Navarre and John Kingsley and I thought it might be a little cumbersome, but maybe not, is instead of the LASA board kind of ratifying or approving whoever the nominee is or person recommended by whatever community group, whether it's 100% or 80%, it could also not be the LASA board. It could be, you know, the SIO and Webster boards, or it could be the SIO and Webster's, you know, supervisor or whatever it is, but some elected public kind of ratification. And that is what's so unusual about this, is to have and I understand because of the history of it, is to have a private entity directly appoint to a public body without it's not like there's a governor's appointment, right? It's an HOA appointment.
Well, Matt, the articles that we have that are presently in place with the 3 amendments, is there anything illegal anywhere? Because it's been thrown around many times that it's illegal.
I mean, I haven't reviewed word for word.
That's a big question.
Yeah, the original articles and each of the 3 amendments.
Okay.
Okay, to my understanding, no, they comply with Act 233 of 1955, which, I mean, the section 124.283 sets out what the articles of incorporation are supposed to do. And I mean, to my knowledge, no, there isn't, it's not, there's nothing illegal or that's in violation of that. But again, I haven't read them word for word. I was focusing on our Article 7 and the change for how the members were appointed. And there's nothing in the statute that says or lays out any requirements that it can only be the 2 constituent municipalities. I would say that's probably the most common way that an authority such as LASA selects its governing body. But it doesn't require that. The statute doesn't require that.
What's the most common way that the supervisor and the clerk sit on it? That
No,
part?
The constituent municipalities, that's Webster
Yeah.
and Scioto, would, the members of the board of the authority, LASA, would come from those 2 constituent municipalities.
Gotcha.
That's what I believe. We can go out and look at all the various, Detroit Water Sewer Board, whatever, right? But I think that's what would be the most common.
So,
And that's consistent with how you have had your board
Mhm.
for, this
forever.
almost 70 years that it's been in existence, is that, except for the change starting in 1971, where you said 1 member would be from, appointed from LAIA, everyone else has been from the board of either SIO or Webster.
And sorry, just one, at the beginning, it was the full boards. We were each 5-member boards, so all 10 of us met together.
Oh, wow.
So, and those old minutes reflect that. So it was both full boards for, 1957, and then in the 70s, LAIA was added as a seat.
Yeah.
Article 7, the first sentence of the first Articles of Incorporation from 1957 say the governing body of this authority shall be a board of trustees which shall consist of 10 members. Membership on the township board of either Webster or SIO shall automatically constitute such member a trustee of the authority.
Yeah, that's when both townships only met, they were open on Wednesdays from 9 to 12. But I think what happened, I'm just speculating here, is that as the townships grew and all board members were like, yeah, we don't really want to be, all of us be on this board. So they compromised that the supervisor clerk, a member, another member, and then there's that, 3 from each, and then there's this seat that's open. How do we fill that? Oh, Loch Alpine Homeowners Association. I'm speculating.
Yeah, it went from, it went down from 10 to 7 in the first amendment. And then the township supervisor and clerk of each of the incorporating townships, and a 3rd member from each township board to be selected by such township board.
Mhm.
So take SIO, for example. So then the supervisor and the clerk on the LASA board automatically. Then the SIO board, the entire board, selects a 3rd member of its board to serve on the board of LASA.
Or from the community.
No,
I think it
No.
had to be from the
No.
board.
a 3rd member for each township board to be selected by such township board. This is at least the first amendment.
Yeah, and Article
Article
Amendment
7.
3 as well says the same.
And then the 7th member selected from by LAIA. So you've always been locked into at least 6 members being from the township boards. And that's consistent with how the restated and amended articles are drafted, that 3 members shall come from the board of SIO and 3 from, well, actually, no.
It is a
Sorry.
qualified elector who could.
The proposed now says 3 members shall be appointed by the Webster Township Board of Trustees. 3 members shall be appointed by the Scioto Township Board of Trustees. So you don't have to necessarily be on the Board of Trustees now
No.
to be appointed.
Yeah.
Well, that's the proposed amendment.
That's the proposed.
proposed.
Well, but also under current, I want to be,
No, it's not.
Article 7, in the event that any member of the authority board who's a member of the township board chooses not to serve, that member may nominate any person who's a qualified elector of that township.
Correct.
Right.
And that's,
That it's approved. I mean,
And-
that's how we got Patrick.
and that's the one that I dislike.
Right.
Right, me too.
That's the one that I dislike seeing. I'm fine with supervisor, clerk, and then somebody picked by the board. I'm not fine with the clerk or the supervisor deciding they don't want to sit on the board and that they can pick anybody. I think if that's the case and that person decides they don't want to sit on the board or even obviously the board member that's sitting on the board, they shouldn't be able to pick who replaces them. That should go to the board and the board should pick who that's gonna be from themselves again.
So the question then is, do you like the change to say 3 members appointed by the Webster Board of Trustees and 3 from SIO, taking away the requirement that those 3 people also be on the board of SIO and Webster?
Yeah, I don't
Yeah,
like that
I don't
change.
like that either. And I'm
And-
not comfortable because we were elected by the people. And if the board says, no, none of us want to be on, but we're just gonna, pick 3 members from the public. We were elected to serve our community and we've taken an oath to do so. So by us already having that oath, we are also taking this position seriously in my
The oath
opinion.
doesn't mean though that you have to also serve on this board automatically.
No, it's
But-
just that there's more of a, I don't know what the word is, that we have more of investment in it because we have run for office. Where if somebody just off the street we appoint, they don't have that same.
Yeah, I think in most cases though, if there are board members from SIO, I'm just using SIO for as an example. All right, it's time for us to appoint the 3 members that we can elect to SIO. I think in most instances, due consideration is gonna be given to existing board members that want to
Continue.
serve.
Yeah.
It's not a guarantee, obviously.
Right.
But the way it's currently drafted is that those 3 have to come from the board.
Yeah.
Subject to the situation, Jessica, that you mentioned, that if one refuses to serve or
Right.
rejects,
And see,
nods.
I think that's the caveat that they have the option to not serve. And then the board will appoint it. It falls back to that anyways. But the clerk and the supervisor are the ones that a lot of times get those kind of calls too, that come in as far as service in LASA or things like that. Not that you're not gonna get billing calls, because you are. But to that end, I think that section is fine, with the exception of if neither one of the people there want to serve, then that goes back to the board. They don't get to pick who's going to serve for them. I really don't like that part. So then the board can decide who's going to do it. And in the event that, a new election comes and those people are like, the clerk or the supervisor says, I really don't want to sit on that, or I don't have time to sit on it, then the board figures out who's going to be on it. So that's the change. That's the one change I'd like to see. The other thing is, and we had kind of talked about it or bantered about it a little bit. Yes, we have 2 other organizations that make up 20% or so I don't know the exact numbers, but is that something that maybe we offer for those people? It's not a decision-making body, but to sit on operations,
It is a decision-making body if we allow it to be. I mean,
if we allow it to be.
which it has been historically.
So, well, then maybe,
And our articles as our, sorry to interject, but our articles as our state that the operating committee is comprised of 3 people on this board. So there's not more space unless
that's, well, unless we,
revisions.
yeah, unless we did a revision, it would have to be, but
Well, you could revise that, you know, as part of the restated and amended articles.
Right.
certainly. 'Cause right now, the proposed language is the board shall select an operating committee consisting of the chair of the board and at least 2 other board members.
Right.
And may include additional members from the board and or persons from the loss of service area.
right.
But they shall have at least 1 board member from each township on it.
That's proposed, but
That's proposed.
currently it's just the 3, which is why, you know, with the pay issue, when the operating committee was really active, you know, it's the 3 members of the board meeting and meeting and meeting and meeting and meeting,
Yeah,
primarily in operating committees.
yeah. I don't,
So I mean, at this point, what do you propose that we, you know, do you want the committee that was appointed to meet again and, you know, with me, are you, you know, are we going back to the existing article for appointing board members subject to proposed change that if someone declines service, that decision goes back to, I suppose it would be each township board, right? The SIO board or the.
right, they would make.
Or the Webster board.
Process question. You know, part of what Jim did was he restated these. Does the board want to ask Matt to work from restated articles? Or does the board want Matt to go back to the original articles with the amendments and then work on another amendment? Because,
No,
I mean, that's a process
but
question.
Yeah.
what I would like is for this LASA board to sit down and go through the articles and with the changes.
On another day.
Yeah,
I
like
would
a-
agree
a-
with
a-
going through the whole board and bring this again for another day and then hash this out and get to the point where we can
Yeah, so
get
Mark,
writing something.
so that would be going back to what's currently in place, I think. Going through it and marking it up on what we have issues with specifically.
So as far as I can tell, the amendments really deal with Article 7.
Correct.
Which is the process for appointing members. And then you started to get introduced, I think, in Amendment 2, length of terms and the dates that service would commence, et cetera. It got to really be, there was a lot more language added, and then Article 15 was added to the second amendment, just about where it would be published in the Ann Arbor News, so it's not really.
Yeah,
and I
too
think-
They were
significant.
condensed.
The addition of the secretary treasurer as well, that also through the amendments, you know, whether there's a secretary treasurer, secretary in the proposal, the proposed restated ones, that would defer the treasury function to our contracted accountant. Certainly, if this board wants to continue to have a member of this board serve as treasurer,
Yeah.
it can, but I remember when Dave Navarre and John Kingsley and I talked about it, we thought we might want to move away from that. But it's another decision for the board. If you want to continue having, you know, I guess I'm appointed secretary right now. It's technically secretary treasurer, you know,
Yeah, and
I don't,
I'd be interested in talking about what that discussion was and why. They wanted to move away from it.
from an elected treasurer.
Yeah,
Okay.
so I'd be interested in hearing that. I just think we can tweak what's there and as you read, Matt, most of it, when you look at it, most of it's Article 7, Article 7, Article 7. That's what's changed a lot in almost
So-
all of those
So
amendments.
if you go through original articles and decide if there's anything you want to amend. In addition to doing, you know, and include it in a fourth amendment, that would. Sounds like we would. Address and make some changes to Article 7 on the appointment of the board. In terms of service.
Yeah.
And then if there's anything else that you want to address, we could do that in the fourth amendment. Sounds like that's the direction you're leaning, rather than doing a whole new document.
The-
And amended.
Yeah, and Matt, if you could look through, I mean, there's references to things that are just antiquated.
Yes,
Ann Arbor News, these things don't exist, so.
yes, yeah, that would,
Right.
agreed.
And news, you're right. I mean, like newspapers, what,
Now.
like we post in Sun Times, I think.
And I
right?
think-
Legal news, or, I mean, you could just say.
Yeah,
Publication of general circulation, or whatever the statute says. I don't
post
think
on our
the statute-
website.
I don't think the statute requires you to name what the publication is.
Yeah,
We need a publication of note because there's a bunch of different paperwork that Brandon has to file that has to go to a publication of note, and if you got it, you know, just name somebody, so he could file it and say he's done it right.
That's a good idea.
okay. Well, I think we can tweak what's there with some of the issues, so let's take a look at that. And I would say, I would recommend everybody read it from top to bottom. And if there's something you want to change, yeah, come with suggestions, and then we'll set up some time to go through it. The bottom line is right now, I mean, barring that there was an issue, a legal issue, that it's something, we've got a lot of stuff to work on. I mean,
It does say you have to designate the newspaper in the articles, so
Yeah.
you could pick the Washington Legal News or.
Yeah, nobody reads that, though.
The Sun Times.
Oh, I see it.
Right.
Subscription for $85.
right,
What's that?
The legal news that, you have to have a subscription.
Only attorneys
to read it,
the
yeah.
local news.
Yeah,
Yeah.
yeah, it's published, but you know, it's like in the basement, next to the bathroom, in the corner, you know?
we can figure that out, but I think that's a good direction for us to go.
Okay, so everybody read the articles.
Does everyone have all of the articles then?
Yeah.
The original. and
I
all
think
three
so.
3
amendments?
amendments.
Okay. So yeah, I'll do the same. We'll read the original, all three amendments. I'll make some notes as to what, I think, you know, that the restated document attempted to address. If there's anything else of note I see, I'll make a note, and then everyone will do the same.
Yep, and we'll come and
I think if
sit
we
down
have,
and talk about it.
yeah, have a meeting just on the articles because
Yeah,
there's a
We'll do
lot.
just a special meeting on the article.
Yeah.
Yep.
If you wanted.
Oh, what was that? Oh.
It should be short.
well, I mean,
You just said something
Right.
else.
okay,
I'm all for sure.
Okay.
Oh, I'm one of our silent meetings.
Okay.
Good
Any
night.
other questions?
no,
Okay, so, thank you, Matt, for earlier and then now. Well, I guess, the additions we have gone through. So now's the time for public comments. We do not have anyone here present. Clerk Flintoff, anyone online?
Rob Pattinson.
Hi, Rob.
Hi, everyone.
Hello.
I'm a little confused about the loss of response to thousands of gallons of community sewage flowing through a resident's home. We're now at 3.5 months since the event occurred. There's been no news for the community about what LASA will do to resolve the issue. If it can happen to one home, it can happen to any home in LASA. It's nearly a century-old system. And the next LASA meeting is October 6th. So that will be 5 months since the event occurred, and nothing but crickets from this board. There are 7 of you on this board. Imagine if this was your home. Imagine if you had thousands of gallons of community sewage flowing through your home. Imagine the tens of thousands of dollars you're spending on on hotel rental, because you can't spend time in your home because of the stench. Imagine the cleanup, the repair, the renovation, the replacement of so many components of your home. I don't think 5 months is an acceptable time frame for a response from the governing body of the utility to an emergency such as this. I I hope that this board will say something, anything to the LASA community to let them know what's going on and what you're doing to address this. I realize that you're constrained by the potential for lawsuits, but your current um, policy seems to be that you govern by lawsuit, that the only way to get a response from this board is through a lawsuit. And that doesn't seem to me to be a very fair or ethical way of governing a utility. I think this board has a lot to think about and a lot to address. You are willing to talk about how to restructure um, a century-old utility, but you're not willing to talk about an emergency where thousands of gallons of sewage are flowing through a family's home. That does not seem proper or ethical. Thank you for your time.
Thank you.
Next up, Lucy Cohen. Hi, Lucy. Hi, Lucy.
Can you hear me?
Yes.
Hi.
Okay, thank you. I appreciate Rob. I just wanted to say two things. One is I appreciate the gentleman who just spoke about the issues related to the sewage. Very unfortunate situation. And I can't underline enough how important for this board to look to a resolution and not wait any longer. So I'm not going to say anything more because I think he was eloquent and I think he represents most of the people at LASA. If more people knew, you would have tremendous response in terms of how could this have happened and why hasn't this been fixed and why hasn't restitution been made. So that was the first thing. The second, I want to thank you all for this excellent discussion on the articles. I want to thank Matt for his honest legal opinion because this is all we've heard up until now. I'm a member of the LASA board. I have been, I'm sorry, of LIA board. I have been for years. And when this whole issue came up, all we heard was how illegal it was. And we kept asking, what's the law? We had our own attorney from the legal team look at it, couldn't find anything. So to finally have somebody say, it is not an issue of law, it is what you all are wishing to have happen. I hope you consider the strong relationship that Loch Alpine community has with LASA and that you act accordingly. Thank you.
Thank you, Lucy.
No other members of the
Okay.
public.
Thank you. I have a response. Yes, we do have a meeting on October 6th. That's at 3 o'clock, but we also have Thursday, September 11th from 2 to 4, the Operations Committee, and then Monday, September 15th from 3 to 5, we have a special meeting for this board to review J3, J5, J6, J7 from the packet from the other day. And Attorney Jane, could you please respond to what Rob Pattinson?
Would this board like me to respond?
Yes.
I think in public
No.
comment.
Well,
I'd recommend not.
well, yes, what Matt has suggested at this point that we say.
I think one of us should say it.
Yeah. I would just say in terms of the status of the claim, Rob, in response to your comment, it's still under investigation by our insurance company. As soon as there is a determination, Ms. Lucan and the LASA board will be notified.
Okay, well, thank you.
Motion to adjourn?
Yep, at what time? 5:42?
Second.
Support.
Oh.
Sorry, arms.
Yeah.
Okay, all in favor, say aye. Aye. Oppose? None? We are adjourned. Thank you, everybody.
This-